Hello, this is David Olshan of Nevada Legal Services. This is another in our series of instructional videos regarding landlord-tenant law. We're going to be talking about leases and house rules and what's required in Nevada. And you should understand that a written lease is not required. You can have an oral lease. However, the oral lease cannot exceed 1 year, and no lease is okay. But if you do sign a written lease, the landlord must provide, free of cost, 1 copy. You can get extra copies, but the landlord may charge you. If you rent a single-family home, get your lease notarized and keep a copy. Make sure the person renting the home to you is an authorized agent of the landlord. And of course, keep a copy of that lease. If you do not have a lease and the person renting is not an authorized agent of the landlord, you may have a problem. It's called housebreaking in Nevada, and it is a problem if the person renting to you does not act on behalf of the landlord or own the property. So if you do sign a written lease, what's required? Well, the term of the lease, whether it's 6 months, 12 months, 18 months, the length of time that you're obligated under the lease, the amount of rent that you must pay, where and when you must pay the rent. Of course, when you do pay the rent, the landlord's required to give you a receipt. Who pays for the utilities and how much? Who is going to occupy the dwelling unit, whether pets are okay, the services and amenities of the complex, any late fees or other charges. Of course, if late fees exceed 5%, they violate Nevada law, 5% of your monthly rent. The lease must also indicate the deposit and the conditions for refund. NRS 118A.242 contains the law regarding security deposits, but that law must be contained in the written lease. The inspection rights of the landlord must also be included in the lease. But keep in mind the landlord can inspect the property with 24 hours notice. If you do not have a written or oral lease, there's no restrictions on the number of occupants or pets. Keep in mind, building or housing code may limit the amount of people who can be in your dwelling. There's no charge for maintenance or waste removal. There's no late fees or other charges. And if you don't have a formal agreement, you still have to pay rent. You must pay the reasonable rental value of the property at the beginning of the tenancy. And if you're paying for 7 days for a week, it's a week-to-week tenancy. For any other period of time, it's a monthly tenancy. Nevada law also provides protections. So even if your lease contains one of these offending provisions, it's not valid in Nevada because these protections apply whether it's in your lease or not. So in your lease, you cannot have any provisions that violate NRS Chapter 118A. You can't confess to judgment in the lease, meaning you'll move out and pay the landlord any amount that you owe, and that's a confession of judgment. Nothing like that can be in your lease, and if it is, it's invalid. Your lease cannot also absolve the landlord of responsibility for negligence. So if you slip on a banana peel and it's a landlord's fault, you can sue the landlord, even if the lease says you can't. Nevada law invalidates that provision in your lease, and you can sue the landlord. Also, the lease can't provide for more notice or different notice than what's required of the landlord. For instance, if you have to give 60 days notice before leaving and the landlord only has to provide 30, that lease provision is invalid. Also, the lease can't require you to pay the landlord's attorney's fees if you go to court. That is invalid under Nevada law. There can be a provision for the prevailing party, but not simply to pay the landlord. Can a landlord change the lease terms during the term of the lease? No. The landlord cannot raise the rent during the term of the lease. After the lease expires, the landlord can give 45 days notice and increase the rent, but not during the term of the lease. Can the landlord change who's responsible for paying the utilities? No, not during the term of the lease. The landlord may change rules and regulations like pool rules or trash pickup or house rules. Yes, those rules can change. The landlord must give 30 days notice, or the landlord can change the rules sooner if you agree. But these rules must promote the convenience, safety, welfare of the landlord or tenants. They must be enacted in good faith, and they must be sort of a fair distribution of services and facilities, generally speaking. So if a landlord's saying, I'm going to require you not to leave your apartment anymore, which of course usually doesn't happen, but if that's the rule, obviously that wouldn't be valid because it singles you out and it doesn't relate to the convenience, safety, or welfare of other tenants. If you are having a problem with your lease, if you are having any problem relating to landlord-tenant law, please contact us at Nevada Legal Services. We provide free legal assistance if you're eligible. In Southern Nevada, dial 866-432-0404. In Northern Nevada, dial 800-323-8666. We will be providing more information on landlord-tenant issues in the near future. Thank you.